And I have requested to reserve 4 minutes for rebuttal.
Certainly.
Thank you, Your Honor. Your Honors, this case, I guess as a point of clarity first, this case is one of 2 attempted first-degree murder cases with serious bodily injury that I have on the docket today. This first one is the one that involves the motion to suppress that was filed on the morning of trial. Mr. Rickman was convicted of attempted first-degree murder after he shot his adult son once in the shoulder. It was a through-and-through shot. Mr. Rickman's son was the only witness to testify at trial about the injuries. There was no medical proof presented by the state. But he did testify that he lost the use of his arm for about 2 months, and he had a lingering tingling feeling in his arm as well. Our position is that that is a bodily injury, but not a serious bodily injury. So what we're asking this court to do is leave the attempted first-degree murder conviction intact, but vacate the serious bodily injury enhancement, which changes the release eligibility. In this case, as I said, it was a through-and-through gunshot wound, and the state's only theory of serious bodily injury, to elevate this from bodily injury to serious bodily injury, is the statutory phrase whether there was a protracted loss or substantial impairment of the function of a bodily member. The state relies on 3 different points to try and establish that injury. First is the gunshot wound itself, which I think pretty clearly is dealt with in State v. Farmer from the Tennessee Supreme Court. The gunshot wound in and of itself is not an injury. We have to look to the actual injuries sustained by the victim. So what we're really looking at here is the injury, the loss or loss of feeling or loss of use of the arm for 2 months, and the tingling feeling. That's really what we're talking about, not the actual through-and-through gunshot wound. As to the loss of the use of the arm for 2 months, I think the key there is the time. So a bodily injury is a temporary injury. A serious bodily injury is a protracted loss or substantial impairment. And I think, frankly, what this comes down to is it's a little bit difficult to define, right? And even this court and the Tennessee Supreme Court have said serious bodily injury is not susceptible to a precise legal definition. We understand that.
But you're arguing that 2 months is not protracted.
I'm not sure that we're asking for a bright line rule, because I think that's difficult too. And to be candid, this is a jury question ultimately, so we understand that. But as a legal matter, I think the problem in these cases, a lot of these cases, and Mr. Rickman's especially, is that when a juror hears someone's been shot, I think the common sense reaction is, of course, that's a serious bodily injury. But under the law, under the legal standards, the statutory distinctions, this court, the trial courts, are required to look beyond just that kind of knee-jerk common sense reaction.
But again, Farmer was kind of a unique set of facts. The victim basically was saying, I was fine, nothing, the bullet went through, they put like 2 Band-Aids on him, he was released from the hospital, it didn't hurt, I wouldn't, and the court then ruled that was not serious bodily injury. In this particular case, yes, it's a through-and-through wound, but he does sustain nerve damage, and he does lose the use of his arm for 2 months, and he's still suffering from numbness and tingling. So doesn't that a little bit different than just the Farmer scenario?
That's correct. I don't think it's identical to Farmer. That is true. What I think is really important about Farmer is Justice Koch's concurrence that lays out these 2 extremes. On one hand, you have what Justice Koch calls a massive gunshot wound to the heart. Obviously, that's a serious bodily injury. On the other end of the spectrum, you have a graze to the elbow, I think is the example, a gunshot wound grazing an elbow. This case is somewhere in between there. And I think this is why it's so important, even though the state is not required to put on medical proof, that it ought to put on medical proof if it wants to carry its burden beyond a reasonable doubt. Because here, it should not be about what I think is temporary or protracted, or what the court thinks. And it is up to the jurors, I understand that. But ultimately, as a legal matter, we have to look at the proof that was put on. And so all we have is Mr. Rickman's son testifying to the loss for 2 months.
And the jury heard it.
Yeah, that's correct, Your Honor.
And they made a credibility determination about his version of what happened and what he suffered from.
That's true, yes. I think part of the problem is that when we're talking about what does the statute mean, what is the statutory language, protracted loss or substantial impairment? And when this court looks to, because those aren't defined by the statute, when we look to the dictionary definitions of those words, it's considerable, it's significantly great, it's prolonged, delayed or prolonged in time. And so when we look at the legal definitions that our legislature presumably was incorporating into this statute, that's the question for this court. And so when we were talking about a 2-month loss of the use of the arm, I don't think it's a good idea for the court to say, well, anything less than 2 months is not protracted, anything longer than 2 months is protracted. I don't think that's a good idea, and that's not what we're asking for. But here, when all we have is lay witness testimony about loss for 2 months, he then testified that he had been gainfully reemployed as a mechanic, which was his prior job, and Mr. Rickman's son, the victim, testified that there is nothing about this injury that affects anything he does now as compared to what he did before. That was his testimony. There's nothing about this injury that affects me now that I couldn't do before I was shot. That, I think, is what we need to be focusing on.
So if anybody makes a full recovery from a serious injury, then therefore it's not serious bodily injury?
Not necessarily. Again, I think every case has to stand on its own facts. And in this case, when that's the testimony that we
Who determines
have.
the facts?
I'm sorry, Your Honor?
Who determines the facts?
This is a factual question for the jury, and I recognize the
And the
jury.
jury is given a definition.
Actually, I don't think they were.
They're given the jury charge, talk about the difference between serious bodily injury, which is charged, and bodily.
That is
bodily
correct,
injury.
yes, Your Honor. They are read the statutory, they're not given a definition of protracted or substantial, but they are told bodily injury is this, serious bodily injury. That's correct, yes.
Okay.
But I think, again, coming back to the legal question is, has the state put on sufficient proof as a matter of law to go from that bodily injury to the serious bodily injury? And I understand the jury found that in this case, but like with any sufficiency argument, our position is what little proof the state put on here just was not enough to meet that burden. I would point out as well, again, if we look at either Farmer or other cases, there are plenty of cases, and the cases the state has relied upon, some of the cases we have cited, that list out the additional proof that the state has put on in other cases. They just did not do that here, which is why we are focusing not so much on a bright line rule, but the totality of what we have. And this is Mr. Rickman's son's own testimony saying that what the lingering tingling feeling does not affect him now. I understand the 2-month loss of his use of his arm, the court may view differently, and that's what we're saying is temporary, not protracted or substantial. And again, looking at the bigger picture, being reemployed and recovering fully from that would be something to take into account. I forgot to mention at the beginning, we did also challenge the sufficiency on one of the aggravated assault charges. I intended to rest on the briefs unless the court has any questions on that. And then I did want to discuss the suppression motion a bit in terms of the timing. So to back up exactly what happened here. So trial counsel and the prosecutor go in on the morning of trial, and the trial judge asked, before the jury is sworn, before anything starts, the trial judge says, are there any motions that I need to take up? And trial counsel made, at that time, an oral motion to suppress Mr. Rickman's statements that were made and captured on the arresting officer's body cam video.
Let me interrupt you right there, because
Yes, sir.
this is something I wanted to ask you about. I realized, by the way, you wrote an excellent brief, as usual.
Thank you.
I enjoyed reading it, and when I got to this part, I started thinking about having been a trial judge. All three of us have. And the idea, technically, your brief may be correct, that this Rule 12 motion can be brought anytime before the jury's sworn or what. But I thought about the situation where a trial judge has a room full of jurors waiting, we're ready to go here, morning of trial, it might be 9:30. And are there any motions we need to take up let's get going here. We got citizens waiting outside. And here comes it's not even a written motion, an oral motion to suppress a statement. And I'm just having some trouble trying to, and the trial judge says words to the effect of, we're not going to do that now. It's too late. Now let's get going, get the jury in here. And I'm having a lot of trouble not being sympathetic to that ruling, just on a common sense, practical basis. And then when I continued reading your brief, or it might have been the state's brief, there are some cases that basically say under those circumstances, I don't know if it uses the discretion of the trial court, but it's been upheld for where the trial court the appellate court said, it's all right, trial court, you don't have to do it that way. So tell me how this case is different than just where I am on my default position, which is pretty much, a motion to suppress should have been filed in writing well before trial, litigated properly, and not caused the whole, whatever county this was in, the jury, all of it just to screech to a halt while the trial judge did what more properly should have been done well prior to trial.
I completely agree, Your Honor. This is not ideal. This is not ideal in any way. But I think that this situation is different, both from the situation you described and the case law that the state brought up and that we address in our reply brief, for a couple of reasons. Number one, I think that if this trial judge, when he asked, are there any motions I need to take up, and counsel said, here's my motion to suppress orally, not in writing, which under Rule 12 technically is okay, but again, not a great practice. At that time, I think if the trial judge had said, as Your Honor just described, that's too late, we've got the citizens here, we're about to pick a jury, that's untimely, then maybe I don't have as strong of an argument. But that's not what happened. The judge, the prosecutor, the trial attorney, the defense counsel, it appears from the record they stepped out for the judge to actually watch the video, the body cam footage. That's why I think this is different. When you watch this 3.5 minute video, the Miranda violation is clear. And so if the judge had not even entertained it, I think we're in a different position. But because the trial judge, and actually I should back up and say first the prosecutor said, well, judge, you can't wait till after the jury's picked or it's waived. You have to take it up now if you're going to take it up. And defense counsel said, Your Honor, if that's the rule, then I don't want to waive it. Let's do it. And the judge, again, instead of saying, well, no, it's too late, stepped out and actually watched the video. Doesn't appear from the record if there were arguments made, at least in the record, there are no arguments made on the merits, but it is clear that they did step out for the judge to watch the video. So I think that's why it's different. We've already put the citizens on hold at that point.
And then what's the next thing on the record after that?
The next thing, they come back into the courtroom, they're back on the record of the transcript, and the judge says, okay, I'm denying the motion to suppress. I think the judge specifically said because it would be unfair to the state at this point, again, sort of relating to timeliness, and then let's go pick a jury. So then they go straight into picking the jury at that point. The judge's written order denying the motion for new trial on this point clearly rests on the timing, not the merits of the motion to suppress. But the cases, the appellate court cases that affirm trial court saying before trial under Rule 12 means something other than the morning that the trial is scheduled to begin. I think that's a good rule. I do, again, in practice. But in this particular case, where the judge at least started to entertain the merits and the Miranda violation is so clear on the video, and you have the prosecutor being the one to tell the judge, if you're going to take it up, you need to do it now, and the one witness that the state would have needed for a hearing on the suppression motion, if you even needed one at all, is the arresting officer who was there that day to testify for trial. So I understand we're not asking the court to change the rule that, yes, counsel, please come in the morning of trial and make oral motions. We don't want that happening as a practice. But in this particular case, I think that the circumstances were sufficient for the trial judge to make a ruling on the merits and grant the suppression motion because it had gone ahead and watched the video at that
Is the
time.
video in the record?
It is, Your Honor. The video is in the record. We have asked the court to review it, whether under plenary review or plain error review. Again, I think the Miranda violation is blatant from the video itself. The last thing I'll note, I'm not sure that it is clear from the record when trial counsel developed a medical condition, but I should have clarified up front. The public defender's office was appointed to this case after this case was already on appeal, and trial counsel withdrew due to a medical condition. I'm not sure the timing of that, but I think, again, that's another sort of extenuating circumstance here in terms of considering the timing of this particular motion, how the trial judge handled it, and the fact that a ruling on the merits very clearly could have been done, and again, very quickly at that time. So for all those reasons, if there are no further questions, we'd ask the court to leave the attempted first-degree murder conviction intact, vacate the serious bodily injury ruling, or to remand for a new trial on the Miranda violation. Thank you, Your Honors.
All right, thank you. General Coleman, good morning, sir.
Good morning, Your Honors, and may it please the court. Ronald Coleman on behalf of the state. This court should affirm the defendant's judgments because the evidence overwhelmingly established his guilt, both with regards to the attempted first-degree murder by causing serious bodily injury and the aggravated assault on the grandchild. It should also affirm because the trial court properly denied the oral motion to suppress as untimely. And I'll take the issues in the same order that opposing counsel had, unless this court has questions. So first, the evidence established serious bodily injury. And I think first and foremost, it's important to remember what this issue is couched under, and this is a sufficiency challenge. The question is, could a rational juror reasonably find that the proof established serious bodily injury? There's not a statutory interpretation question. There's not a new rule of procedure where medical proof must be put on. It is a question of could the jurors in this specific case have found that the defendant inflicted serious bodily injury on his son when he shot him in the back. And here the proof does show that. I don't think the facts are really at issue. The defendant shot his son in the back. It went through the son's shoulder and caused the loss of the function of the use of his arm for 2 full months. And then he continues to suffer from tingling and numbness in that arm. That simply is serious bodily injury. Again, the prong of serious bodily injury can be established, I believe, 5 or 6 different ways. One of those is the protracted loss or substantial impairment of the use of a bodily function. The defendant seems to be arguing only that 2 months is not protracted, and that's for the jury to determine.
What about the fact that he was able to go back and do everything? If the testimony is, he basically has no impairment from this.
Does not matter one bit. The question is, how protracted was the loss of that use? Or was the loss of the use of his arm sufficient enough to be considered protracted by the jury? Whether he makes a full recovery after the fact doesn't matter. The jury could look at that 2 months where he wasn't able to use his arm and say, that's a protracted loss of the use of your arm, one of your 4 limbs, and simply establish that that was on its own serious bodily injury. Also, the fact that he simply had the impairment, I think it's much more fleshed out in the case this court will hear later this morning in Ambria, Washington, but the statute says protracted loss, which is one of the ways you can establish it, or substantial impairment. And this certainly qualifies as substantial impairment, and there's no time limit on that. But again, both parties have submitted multiple briefs for comparison, but I think there was a quote earlier by my friend on the other side. Every case has to stand on its own facts. The question here is, could the jury determine that 2 months of not being able to use your arm constituted the protracted loss of the use of that arm? The answer here is yes.
This jury got all the instructions with all the...
That's my understanding. Again, there are no legal definitions or pattern jury instructions with regards to defining what protracted loss is or what substantial impairment is.
Right.
That's for the jury to determine, and they can use their common sense in saying, again, losing.
They got the basics on what would be a substantial bodily or serious bodily injury.
Correct. I believe the judge included, I don't know if the judge included all 5 prongs, but certainly the jury instructions said you have to find that serious bodily injury was established. Serious bodily injury includes protracted loss or substantial impairment of the use of bodily function.
Yeah.
Unless this court has further questions on that or on the aggravated assault of the grandchild, I'll rely on my brief as well on that. And then turning to this last issue of the suppression, I do want to clarify my understanding of the record. There was a claim that the judge went out to watch the video, and my recollection of the record doesn't establish what they go outside for. The proof is that the jurors are in the courtroom. They are ready to go, and I think the judge wants to have sort of almost a sidebar conversation and says, let's step outside to do that. So I don't think there's anything in the record that the judge has considered the merits or has watched any part of this video at the time it makes its ruling on suppression.
We just know
on the
there's
motion.
an untranscribed
It says they step outside.
hearing or discussion off, not in front of the jury.
Correct. They step out into a hallway and they come back, and I think, Judge Eric, you asked the question, and the court said, quote, "This puts the state in a prejudicial position for not being able to prepare." So the court's looking at this timeliness issue from the get-go and saying, like, to your point, Judge Wiedemeyer, this is, the court's saying this is the day of trial. We're ready to go. And the rule in case law support a dismissal for untimeliness of the motion.
Well, is it untimely under the rules?
It is. So the rules uses the language prior to trial, must be filed prior to trial. And 2 cases, Kinner and Hamilton, have elaborated on what prior to trial means. And they say that it must mean something, it must mean more than the day of trial. And I think Hamilton goes beyond that and says you can't have the jury in the courtroom ready to go and make this motion. That's just not feasible. And it goes to sort of the practicalities of this. This is to detract and deter sort of an ambush by defense counsel of waiting. Now, and I'm not necessarily suggesting here that defense counsel was being malicious at all, but it goes to the practicalities and to the overall policy implications. And you've got to make this motion prior to trial, meaning before the day of trial, when the jury is in the courtroom, when there's so many jurors there that the court and parties have to step out into a hallway to have a conversation. That's just untimely. And the court properly dismissed it as untimely. But even if this court were to determine that it was timely somehow, there was no suppression warranted here. There was no Miranda violation. The defendant argues that it's clear that there was a Miranda violation. To be Miranda, you have to be in custody and interrogated, and the totality of the circumstances look at that. So first, the defendant here wasn't in custody. He had freedom of movement. The officer did place him in handcuffs, but at that time, the officer very clearly explained, I'm doing this for my safety. I'm just doing this till I can figure out what's going on.
So someone in handcuffs doesn't think they're in custody?
I think it depends on if there's that clarification. If the officer says, like, you're not under arrest, I'm just doing this because, there's a shot fired and I'm doing this for my safety to figure out what's going on, I would submit that no, they don't feel that they're under arrest, especially when they later push back and the officer says, okay, we're going to walk over here, go sit down over there. And instead of following those instructions, the defendant pushes back and says, no, I'm not going to do that. I want to sit on this chair because I'm going to do what I want to do. So they have freedom of movement there. And even if this court determines it's in custody, there's no interrogation here. This court has the video. Judge Ayers, the video is in the record. And the comments in question, first the defendant spontaneously makes the first comment while the officer has his back turned to the defendant and is attempting to secure the revolver. And he's having some difficulty with it. So he is fiddling with the revolver on video while the defendant behind him makes an unlisted statement, and he says something along the lines of, why don't you tell me what happens, and continues to fiddle with this. So under the totality of the circumstances, this isn't an interrogation even. And so the state would submit that if the motion to suppress were timely filed, it would have been granted. And then we've still got another belt and suspenders argument, which is that even if suppression of the video should have been granted, it wouldn't have had any impact on the outcome of trial. The defendant, there's no question the defendant shot his son in the back. No one's disturbed. No one's arguing that. No one's arguing that he then pointed the gun at his daughter-in-law and at his grandson and made threats to them. No one's really arguing any of that. So the fact that the defendant admits to shooting his son on video and gives a reason that is exactly the same as what his reasoning is at trial, there's no harmful effect of this. So again, the evidence overwhelmingly establishes guilt. The motion to suppress was untimely, and to the extent that it was timely, there's no error there. And unless this court has further questions on either of those issues, we respectfully ask that you affirm the judgments. Thank you.
All right, thank you, General. In fairness, your brief was also excellent. Certainly. This was a very interesting case to read about, in the briefs, I mean. Rebuttal.
Thank you, Your Honor. Briefly on rebuttal, I want to point out first onto the serious bodily injury issue. When we're talking about the tingling and the numbness, I want to be clear that the victim testified that did not cause him any pain. And that was the specific reference where he said it did not prevent him from doing anything he did before. So we recognize that is
And it was still ongoing.
Exactly, that there's still some side effects there. But again, his testimony was no pain and did not have any effect. So that goes to the use or whether there was impairment. So when we're looking at the legal terminology here, that just doesn't fit.
Well, let me just say this. There's a difference between protracted, which what the statute requires, protracted versus permanent. There's
That's correct.
nothing in the statute that requires permanent damage. It just has to be protracted. And that goes back to, as far as sufficiency isn't that a jury question?
Correct. So the statute says protracted loss or substantial impairment.
Mm-hmm.
And so whether we're talking about protracted loss or substantial impairment, we're talking about the function, the use of the member. And that's our point here, is when we have testimony that it does not impact the use of his arm, it does not meet that definition of serious bodily injury. It could in another case, we acknowledge that, but in this case, when that's the testimony, the state has not carried its burden there. As to the suppression issue, the Kinner case and the Hamilton case, just a few notes on those. In Kinner, the motion to suppress, or the motion under Rule 12 in that case, was made at some point during trial, and it was not presented to the judge for consideration. I hope I'm not mixing those Kinner and Hamilton up, but I believe it was Kinner where the motion was actually made. It seems like, from the way that opinion is written, perhaps a law clerk or someone at the firm went and filed it with the clerk's office while the other attorney is in court during trial. That's the impression I get from the Kinner case. That's obviously too late. Hamilton, it's unclear when the motion was filed, but Hamilton also talks about the underlying purposes behind Rule 12 that are not implicated here. Things like distracting the jury, interrupting a trial that's in progress, or prejudicing the state. Those are the reasons why we require pretrial motions.
Well, talking about, you say about prejudicing the state. Let's just say, for instance, the judge decided, okay, I'm going to go ahead and hear it. And then he turns around and says, okay, I'm going to grant it. So then the state has to appeal. And the jury is sitting there, out in the hallway or wherever it is, and everything has to get put on hold. When this could have all been avoided had it been argued and presented before. So
Certainly.
it does put the state in a bad position.
I disagree with that, honestly, frankly, Your Honor, because the state is saying it doesn't matter. The state is saying those statements don't matter.
Maybe so, but it'd be pretty gutsy just to say, well, we're just going to concede and not, if the court makes a ruling like that, just say, well, we're not going to worry about that evidence. Because the state, that's about the only time the state really has a chance to appeal under those circumstances. And again, the other thing too that puts them in a disadvantage is, and again, an oral motion to suppress under the rule would seem to be highly insufficient because it doesn't get into the basis for, a boilerplate motion to suppress, a filed one, a written one that just says suppress all the evidence would be dismissed as being insufficient under the rule, and just to make an oral one would seem like it would be insufficient under the rule.
Under the plain language of the rule, it actually is sufficient because the oral motion is permitted. I agree the case law sort of expounds upon that and puts these greater limits. Again, I'm not saying this is a great practice. I'm not saying this went very well. But I am asking for this court, under these circumstances, where there was at least a pause in the proceedings anyway. I think the assumption is they watched the video. I'm not sure that that's, I'll leave it to the record for that. But where the proceedings were already paused, we would ask the court to rule that the motion to suppress should have been ruled on the merits and granted at that time. Thank you.
All right, thank you.
Whenever you want to, I'm good either way.
One more and then break is good.
Fine with me? But if-
All right. Call the next case, please. We'll take a short break after the next case.
Carlos Key versus State of Tennessee.